Legal and Privacy Brief for May 29, 2026. The Supreme Court threw out Terry Pitchford's Mississippi death sentence over racial discrimination in jury selection, ruling trial courts must allow defendants to challenge prosecutors' race-neutral explanations for striking black jurors. UK financial regulators called on firms to strengthen cyber defenses against AI-enhanced threats, warning that frontier AI models increase the speed and scale of cyber attacks. Carnival confirmed hackers stole personal information from nearly 6 million customers, including passport and driver's license numbers, after shiny hunters compromised an employee account in April. Here's the full breakdown of today's top legal and privacy stories. Legal and Privacy Brief, May 29, 2026. Next section, Enforcement Actions. Carnival data breach. Carnival confirmed hackers stole personal information from nearly 6 million customers in an April cyber attack claimed by shiny hunters. The threat actor compromised an employee account and access names, addresses, email addresses, phone numbers, dates of birth, driver's license numbers, and passport numbers. The company acted swiftly to block unauthorized activity and engaged third-party security experts to strengthen security. Maine's Attorney General filing indicates approximately 6 million individuals were affected. Compliance action. Organizations operating customer loyalty programs should review employee account security controls, implement multi-factor authentication, and conduct phishing awareness training. Review breach notification procedures to ensure compliance with state attorney general reporting requirements. Sources: The Record. Trump Mobile data leak. Trump Mobile confirmed exposing customer names, email addresses, mailing addresses, cell numbers, and order identifiers to the open internet. The company blamed the exposure on an unnamed third-party platform provider. The leak affected customers who paid $100 deposits for Trump-branded phones, which remain largely unshipped nearly a year after launch. Source: TechDirt. Next section, Litigation Updates. Pitchford v. Kane, Supreme Court. The Supreme Court threw out Terry Pitchford's Mississippi conviction and death sentence in a 5-4 decision. Justice Kavanaugh wrote that after a prosecutor provides race-neutral reasons for a peremptory strike, defense counsel must have an opportunity to argue the asserted reasons are pretextual. The Mississippi trial court erroneously omitted this key part of the Batson v. Kentucky inquiry. The case returns to lower courts for further proceedings. Pitchford was convicted in 2006 after the prosecutor used peremptory challenges to exclude 4 black potential jurors in a county with a 40% black population, resulting in a jury with just 1 black juror. Source: Scott blog. Disneyland facial recognition, class action. A new class action lawsuit alleges Disney collects facial recognition data from theme park visitors without their consent. The complaint claims violation of biometric privacy laws. No settlement or jurisdictional details have been disclosed. Compliance action. Organizations using facial recognition technology at physical locations should review state biometric privacy laws, particularly Illinois BIPA, the Biometric Information Privacy Act, Texas QBI, and Washington state biometric privacy statutes. Ensure proper notice and consent mechanisms are in place before collecting biometric identifiers. Source: Top Class Actions. Circle K data breach settlement. Individuals who received Circle K data breach notices may qualify for compensation through a class action settlement. Settlement terms and claim deadlines were not disclosed in available materials. Source: Top Class Actions. Anthem Proton Beam Treatment Settlement. Anthem agreed to pay approximately $3.6 million to resolve a class action lawsuit alleging the company improperly denied insurance coverage for proton beam radiation therapy used in cancer treatment. Settlement provides compensation to class members whose claims were denied. Source: Top Class Actions. Oklahoma v. Roblox. The state of Oklahoma sued Roblox, alleging the gaming platform failed to adequately protect children from sexual predators despite marketing itself as a safe environment for minors. The lawsuit claims the company's safety measures are insufficient given documented incidents of predators using the platform to target children. Source: Top Class Actions. Next section, Regulatory Guidance. UK Financial Services. AI cyber threat response. The Financial Conduct Authority, Bank of England, and HM Treasury issued a joint statement calling on UK-regulated financial services firms to address cyber risks from frontier AI models. The statement does not introduce new regulatory expectations, but emphasizes that existing obligations require firms to respond to AI-enhanced threats. Frontier AI models help threat actors identify and exploit vulnerabilities more quickly, increasing the speed and scale of cyber attacks. Compliance action. Financial institutions should brief boards and senior management on frontier AI threat models document scenario testing and operational resilience reviews under CISC 15A, and review incident response plans for AI-accelerated attack scenarios. Ensure compliance with Principle 3 systems and controls requirements in CISC 4. 1R governance standards. Source: Debevoise Data Blog. Emergency Docket Precedent Analysis, a citation analysis of 475 substantive Supreme Court emergency applications filed between 2000 and 2024, found that 53% were cited by at least one federal court as of October 2025. The Supreme Court itself cited 11% of these decisions in subsequent rulings, including major merits opinions. Emergency docket cases with written opinions averaged 45 citations each, compared to 10 citations for minimally reasoned orders. Total citations increased 63% between April 2023 and October 2025, indicating courts are accelerating use of emergency precedent rather than reaching equilibrium. Compliance action. Litigation counsel should track emergency docket decisions in relevant practice areas, as lower courts increasingly extract precedential value from Supreme Court emergency orders even when minimally reasoned. Source: Scotto S. blog. Next section, privacy developments. Data broker location, tracking of military personnel U.S. Central Command reported receiving multiple threat reports concerning adversary exploitation of commercial location data to target or surveil U.S. personnel in theater. Pentagon officials confirmed enemies are using location data purchased from unregulated data brokers to target and kill U.S. troops overseas. Senator Ron Wyden stated commercial location data can be used to identify where U.S. troops congregate and their patterns of life, which adversaries exploit for missiles, drones, roadside bombs, and counterintelligence. Wyden called for treating the tech industry as a national security threat. Compliance action. Organizations collecting or selling location data should review customer vetting procedures, implement controls to prevent sale of sensitive location data to foreign actors, and assess national security implications of location data monetization. Consider voluntary restrictions on sale of location data near military installations and sensitive facilities. Source: TechDirt. Age verification privacy. Concerns. EFF warned that online age verification schemes force users to reveal sensitive personal information to third parties simply to access the web. Once centralized, this data becomes a target for leaks, hacks, and misuse. The organization stated that age verification mandates justify government-led censorship and expanded surveillance, and that these powers are historically abused. Compliance action. Organizations subject to age verification mandates should implement privacy by design principles, minimize data collection, evaluate third-party age verification providers' security practices, and document data retention and deletion policies. Monitor state-level age verification legislation and prepare compliance frameworks. Source: EFF Deep Links. 2026 FIFA World Cup phishing campaign. Chinese-speaking fraudsters built near-pixel-perfect clones of FIFA official website across more than 300 domains to steal credentials and payment details from fans seeking 2026 World Cup tickets. Group IB designated the Operation Ghost Stadium and observed it using a phishing kit developed with Leui 2.7.6M, a Chinese open-source UI library. The phishing kit clones FIFA login system and requests password reset parameters, enabling attackers to lock victims out of their accounts and resell legitimate tickets. Group IB estimated potential victim count exceeding 47,400 people for premium ticket fraud alone, with losses between $71 million and $474 million for that tier. The campaign was distributed through paid Facebook advertising. Compliance action. Organizations operating ticketing systems should implement FIDO2/web authentication, monitor for domain type squatting, establish takedown procedures with registrars, and educate customers to only access official sites by typing URLs directly. Review social media advertising fraud policies and reporting mechanisms. Sources: The Record. Justice Barrett swatting incident. Justice Amy Coney Barrett was targeted in a swatting incident on May 27. Fairfax County, Virginia police responded to a false call reporting gunshots at her home, but quickly realized it was a swatting call after meeting with her security detail. The justices have had around-the-clock security since at least 2022, following the Dobbs draft opinion leak. In 2022, a California man was arrested and charged with attempting to assassinate Justice Kavanaugh at his home. Source: Scotto S. blog. Next section, policy changes. USCIS green card policy change. The Trump administration announced foreigners in the U.S. who want a green card must now leave and apply from their home country, reversing longstanding policy. USCIS stated people who provide an economic benefit or national interest could likely stay in the U.S., while others would have to go abroad to apply. The agency described the change as returning to the original intent of the law and closing a loophole. The policy has operated without such restrictions for over 5 decades. Compliance action. Employers sponsoring foreign workers for green cards should review pending adjustment of status applications, assess which employees may qualify for economic benefit or national interest exceptions, and prepare for extended timelines as employees travel abroad for consular processing. Update immigration budgets and timelines for affected positions. Source: TechDirt. DOJ, the Department of Justice. Grant terminations. The Department of Justice terminated 365 previously awarded grants in April 2025, eliminating approximately $500 million in promised funds, affecting more than 550 organizations across 48 states. Terminated programs included community violence intervention, victim services, law enforcement training, juvenile justice, offender reentry, and criminal justice research. The DOJ's fiscal year 2026 budget proposal reduces public safety and justice program funding by an additional $850 million, approximately 15% below the prior year. Programs implementing the Second Chance Act lost $40 million in funding. Project Safe Neighborhoods lost training funds. An anti-terrorism program that trained more than 430,000 state and local law enforcement officers since 1996 was terminated. Source: TechDirt. California Protect Our Games Act. California's Protect Our Games Act passed out of committee. The bill would require digital game publishers who cut off support for an online game to either provide a full refund to players or offer an updated version enabling continued use independent of operator-controlled services. Publishers must notify players 60 days before cessation of services necessary for ordinary game use, including the shutdown date, services no longer provided, unavailable features, security risks, and how to continue using the game or obtain a refund. The act would not apply to completely free games and games offered solely for subscription duration. The law would apply to any game offered for sale in California on or after January 1, 2027. Compliance action. Digital game publishers should review product roadmaps and support lifecycles, document server dependencies and offline functionality capabilities, establish sunset notification procedures with 60-day lead time, and prepare refund processing systems. Evaluate technical feasibility of providing standalone game versions or server software to players after support ends. Source: TechDirt. Next section, compliance takeaways. Financial services firms, subject to UK FCA and BOE supervision, should conduct frontier AI threat briefings for boards and senior management. Review CISC 15A operational resilience scenario testing, and document governance oversight of AI-enhanced cyber risks under CISC 4.1.1R by Q3 2026. Organizations operating loyalty programs or storing customer, passport, and driver's license data should review Carnival breach response as a case study. Implement multi-factor authentication on employee accounts, conduct phishing awareness training, and validate breach notification procedures, align with state attorney general reporting requirements. Companies collecting or monetizing location data should immediately review data broker relationships and implement controls preventing sale of location data to foreign actors following Pentagon confirmation that adversaries are using commercial location data to target U.S. military personnel. Digital game publishers selling in California should prepare for Protect Our Games Act compliance by January 1, 2027, including 60-day shutdown notification procedures, refund processing systems, and technical evaluation of offline game functionality or server software distribution to players. Organizations using facial recognition at physical locations should audit state biometric privacy law compliance, particularly Illinois BIPA, Texas QBI, and Washington biometric statutes, and implement proper notice and consent mechanisms before the Disneyland facial recognition lawsuit establishes adverse precedent. That concludes today's legal and privacy brief. From Carolina Clear Tech, for informational purposes only, not legal advice.